If you are a U.S. citizen and you want to file for your child that's outside of the U.S. to come to the U.S. with a green card and get citizenship, let's talk about how you're going to go through that process. I am U.S. immigration attorney Lilian, and I help my clients get green cards and citizenship for themselves and their families using the U.S. immigration law system. Now, if you have been watching my series on how to get citizenship for your child, well, you know that you can do a CRBA, register their birth abroad. You can do an N600 where they go from green card to certificate of citizenship based on your own citizenship. You can do an N600K for when they are outside of the US, but you meet the requirements for them to be able to get citizenship without ever needing a green card. Minor children of U.S. citizens, meaning children under 21 of U.S. citizens, are considered immediate relatives. That means there is always a visa available for them. A U.S. citizen can file for their minor children. Again, under 21 is what I mean when I say minor children. I do not mean 18. I do not mean under 18. I mean under 21. Okay, once they hit 21, they are no longer considered minor children. They are considered adult children, completely separate category. So today we are just talking about how to get your minor child under 21, from not having any status, from being outside of the US to citizenship. Like I said, if you do not qualify for CRBA, the N600 or the N600K, this is the process you are going to go through. First, you, the U.S. citizen, need to start with an I-130. This is where you prove to USCIS that this child is your child. If you are a father filing for your child that was born out of wedlock, meaning you were not married to their mother when they were born, you want to make sure that you have legitimized the child. Meaning, look at the laws where you live or where the child lives on what it means to legitimize the child, and make sure you have done that before the child turns 18. And as long as you did that, you're able to file for the child. The first step is to file an I-130 with USCIS. This is where you prove that this is your child, that you have legitimized the child if you're the father of a child born out of wedlock. This stage is crucial because if your I-130 is not approved, you are not moving on to the next stage. So it's really important that you document your relationship, especially if the child was born out of wedlock and you are the father. Mothers have an easier time filing for their children because, again, they are the mother, they carried the child, and they birthed the child, right? So USCIS is going to have less of a requirement in that regard. But you still have to show that that's your child, right? You have to prove that you're a U.S. citizen. So your certificate of citizenship, certificate of naturalization, U.S. passport, anything that you have to show that you are a U.S. citizen. You have to show that that is your child, so you can include their birth certificate that shows your name there as their parent. If you were married to their other parent at the time the child was born, make sure you include your marriage certificate to just make the process even smoother. Once you file the I-130, you have to wait for USCIS to approve it before you can move on to the next stage. By the way, if you are getting value out of this video, do not forget to like and subscribe if you are in a place where you can subscribe. Once they approve your I-130, you're going to go ahead and start the consular processing stage. This is where the National Visa Center comes into play. You want to do your affidavit of support. You want to do your DS-260 for the children. For the MVC stage, you want to go ahead and file the I-864 or I-864W. You file an I-864W if your child, when they enter the U.S., will qualify for derived citizenship, which is what I talked about in my video about the N600, where your child, because you meet the physical presence requirement, they were in your legal and physical custody, automatically becomes a U.S. citizen because they entered the U.S. with a green card before they turned 18. They're in your legal and physical custody. Now, because that's going to be the situation, National Visa Center is not going to require an I-864. They're going to want the I-864W that basically says, I don't need an affidavit of support for this child because they're going to be a green card holder for like 2 seconds. However, if your child is already 18, you are going to have to do the full I-864 affidavit of support. Once you provide the I-864 and the DS-260, you also need supporting documents, okay? So the supporting documents for the I-864, again, that's if your child does not qualify for automatic derived citizenship once they enter the US, you will do an I-864. In that situation, you want to include your tax returns, your W-2s, and any other proof of your income that you want to include. For the DS-260 supporting documents, you need the child's passport, birth certificate, and if they are over the age of 14, you need to go ahead and include a police certificate. Once you complete the DS-260, the document checklist is going to pop up. It's going to tell you exactly what documents the embassy wants from you. And you just go ahead and upload those documents and submit them to the National Visa Center. Once it's reviewed by the National Visa Center and no additional documentation is required from you, they will go ahead and let you know that you are documentarily qualified. Once you are documentarily qualified, that means you are in line for an interview. Your child is officially in line for an interview. Once they get to their interview, the officer is going to review their application and ask them some questions or not. Right? Depending on how old your child is, they may need someone to go with them. If you are not able to go to the interview with your child, or their other parent is not able to go to the interview with them, you will need to give someone a power of attorney to go to the interview with your child. This, of course, is if your child is a minor. If your child is not a minor in the traditional sense, meaning under the age of 18, if your child is already over the age of 18, then they can go to the interview by themselves. However, if they are under the age of 18, you will need someone to go with them. And if that is not you or their other parent, you need to give that person the power of attorney to go to that interview with the child. Please note that at any point in this process, either at the I-130 stage or the MVC stage, there may be a requirement to do a DNA test, and you will just follow the requirements that either USCIS or the MVC has provided to make sure that you are doing that DNA test correctly, because there's only certain labs in the US that is allowed to do those tests. And part of the test is getting the DNA sample from the child at the U.S. Embassy where the child lives. So you want to make sure you're going through that whole process correctly and that the lab is certified by the U.S. government to do those DNA tests. Once your child goes to the interview and is approved, they will have to give the officer their passport and wait for that visa to be put in the passport. Once they get that visa back, they are able to now travel to the United States. When they enter the US, they will have their visa, their passport, and a stamp in the passport that shows when they entered and when they were admitted into the US. Like I said, if your child is under the age of 18 when they enter the US and they are going to be in your legal and physical custody, and you already meet the residency requirement, the physical presence requirement of an N-600, guess what? The second your child enters the US, they are now a US citizen, which means they can go straight to applying for a US passport and applying for the N-600 certificate of citizenship. If they are over the age of 18, they need to wait 5 years of having their green card before they can apply for citizenship using the form N-400. So it really comes down to how old they were when they entered the US and how many years of physical presence you already have in the US. And they may already be a US citizen the second they enter the US, or they have to wait that 5 years before they can apply for citizenship. Now, quick recap. If your child is outside of the US, and you want to file for them as a U.S. citizen to get citizenship in the U.S., and they do not qualify for the CRBA, they do not qualify for an N600K, then you will have to go through the I-130 process. So you'll start with the I-130, proving to the U.S. government that they are your child. Then you go to the MVC stage, proving that they qualify for a visa by filing the I-864 or 864W, depending on their age at the time they enter the U.S., and completing the DS-260 and uploading the supporting documents for those. Once you complete that stage, your child attends the interview. Once approved, they can come into the U.S. If you filed an I-864W and they come into the U.S. before they turn 18, guess what? They are automatically a U.S. citizen if they live in your legal and physical custody, and if you meet the physical presence requirement. If you do not meet the physical presence requirement and they're not living in your legal and physical custody, or they are already over the age of 18, then they will need to wait 5 years before they can apply for citizenship. Quick tip here. If when your child enters the U.S., you have not met the physical presence requirement and they are like 5 years old, just know you can still meet those physical presence requirements like I talked about in my N600 video, because they just have to meet all the requirements before they turn 18. So let's say your child is 5 years old and you are able to get your physical presence to the required 5 years while they're in the U.S. as a green card holder. Once you meet your 5 years physical presence, they are automatically a U.S. citizen. So that's why it's really important to look at those videos if you have not watched it already, and think about what you can do and when you should be filing for your child to make sure that they get all the advantages when it comes to applying for citizenship. If you are interested in finding out the best way to file for your child and what that process is going to look like and how I can help you with that process, you can do that by going to my website, lilylegal.com, and scheduling a strategy session. This is a time for us to discuss your situation, your child's situation, and figure out the best plan for you and how I can help you make that plan a reality. You can go to my website, lilylegal.com, click on Contact Us, and pick a date and time that works best for you for us to talk about your immigration goals. You can also call my office at 508-443-1788 to schedule your strategy session.